Hi, I'm Kyle Wormerskirchen. I'm an attorney with Wormerskirchen and Blomquist in Wayzata. In this talk, I would like to talk about three things. One, I want to talk about how Minnesota law treats legal issues in divorce, including children, income, and assets. Two, I want to talk about the legal process to get divorced and what the options are. And three, I want to talk about choosing a lawyer and how you can choose the lawyer that's right for you in your case. First, let me talk about legal issues in a divorce. In a divorce with children in Minnesota, there are 5 things that the court has to figure out. If there are no minor children, there are 3 things that the court has to figure out. So in the first part of my talk today, I'm going to talk about the 5 things that a court has to figure out in a case with minor children. If you don't have minor children, you can disregard the first 2 things that I'm going to talk about. So the 5 things are, number 1, custody and parenting time. Number 2, child support. Number 3, division of assets. Number 4, division of debt. And number 5 is spousal maintenance, otherwise known as alimony. First, talking about child custody and parenting time, I will say there are 2 types of custody. And in your case, if you have minor children, you will have to figure out both of those types of custody. There is legal custody, which has to do with decision making. This has to do with where the children go to school, how medical decisions are made, and how religious decisions are made. Most cases in Minnesota share joint legal custody and make decisions jointly as long as there hasn't been domestic abuse in the relationship. The second type of custody is physical custody. That has to do with where the children primarily reside. That varies on every case, and to the extent possible, courts usually try to continue what the parties did during the marriage. So if one parent stayed home during the marriage and the other parent worked, then the parties will likely have sole physical custody to one parent, and the parent who worked might have parenting time every other weekend and 1 or 2 nights during the week. If the parents really shared parenting responsibilities equally during the marriage, there's a higher likelihood that they're going to share joint physical custody. Once we figure out those 2 labels, then we have to figure out a parenting schedule. And there's a lot of different options for families in terms of ways to divide the week to figure out a parenting time schedule, and every family has to figure out what's right for them. Once we figure out the parenting schedule and custody, then we have to figure out child support. In Minnesota, child support is based on a formula. And generally speaking, if we can figure out the parent's income, child support is pretty easy to figure out. There's 3 parts of child support. There's basic child support, which has to do with money paid on a monthly basis to help support the other parent. There is medical support. Depending on who has the health care coverage, if one of the parents has private insurance through their employer, the other parent is expected to contribute part of the kid's health care premium. Additionally, there's out-of-pocket medical expenses for things like doctor's visits, co-pays, drugs, and, of course, dentists and orthodontics. Those get divided in proportion to the parent's income. So if one parent has, say, 60% of the total income and one parent has 40% of the total income, they will split the medical premiums and those medical expenses that I just described according to that percentage. The third part of child support is daycare. If you have older kids, you probably don't have daycare expenses. But if you have younger kids, as all parents know, those are significant expenses. And those expenses are going to be divided according to the parent's percentage of income. That is the basics of parts 1 and 2 of the 5 things I want to talk about the law, which are custody and parenting time and child support. The third thing I want to talk about is division of assets. In Minnesota, assets and debts are divided equitably. So number 3 on my list was assets, number 4 on my list is debts. I'll talk about those 2 things together. Equitably means fairly, and a court is allowed to divide assets as they think is fair. However, generally speaking, courts believe fair to be 50-50. So in most cases, and I would say a strong majority, maybe 99%, assets accumulated during the marriage are going to be divided equally. Now, make a distinction between assets that are accumulated during the marriage and assets that were brought into the marriage. Assets that were brought into the marriage are considered non-marital assets. So if you had a $40,000 IRA that you had on your wedding day, you will get that money going out of the marriage, plus any appreciation on that money as a non-marital asset. If you put more money into the account during the marriage, that money that you put in during the marriage will be considered marital and it'll be divided equally. If you inherited any money during the marriage, that's also considered non-marital. And so if there was a bequest from a will to your name and in your name alone, that would be considered a non-marital asset. And generally speaking, as long as we can trace it and that money is still there, you get to take that money out of the marriage. I say the word trace because if you, let's say, got a $10,000 inheritance and that money went into your checking account and then you spent it on your monthly expenses like groceries and utilities and that sort of thing, that money's not going to be traceable and you're not going to be able to take that money out of the marriage most likely. The same applies to debt. If you acquired debt during the marriage, that debt will generally be split equally. Now, you should make a distinction between secured and unsecured debt. Secured debt means debt that you acquired to purchase something such as a house or a car where the loan is secured against the asset. That type of debt will generally follow the asset. So if you have a car and there's a loan against the car, you'll probably get the car and you'll get the loan accumulated with the car, and your spouse won't be expected to pay part of that loan. If you have unsecured debt, like a credit card, that is going to be considered marital debt regardless of whose name it's in. So if you have a credit card that's in your name alone and it went to pay for something during the marriage, it probably will be divided equally. Generally speaking, courts don't look much at what the debt was used for. If it's marital debt, it will generally be divided equally. So that's number 4 on my list, division of debts. Number 5 is spousal maintenance or alimony. Spousal maintenance is probably the most contested issue in Minnesota courts, maybe next to child custody. There is no clear guidelines in Minnesota about what spousal maintenance should be in a particular case. The courts look at several issues to figure out whether spousal maintenance is appropriate, and we can generally tell you if you meet with a trusted legal advisor what types of cases are going to be eligible for spousal maintenance. The basic rule is this: the court has to look at the length of the marriage and the disparity in income between the two parties. If there's a marriage lasting, let's say, longer than 5 to 10 years, and there's a big difference in the two spouses' incomes, there's a good likelihood that the higher earning spouse will pay some spousal maintenance to the lower earning spouse for a period of time. How long that period of time is varies, and it depends on the length of the marriage. I can say generally if your marriage is greater than 20 years in length and there's a large difference between the two spouses' incomes, there's a good chance that the higher earning spouse will pay spousal maintenance to the lower earning spouse for a longer period of time. And usually we look at maybe the 6 to 12 year range, but it could also be permanent maintenance. And I use the term permanent, that's in the statute. There's both temporary and permanent maintenance. And in each case in which spousal maintenance is awarded, we have to look at whether it's going to be a temporary award or a permanent award of spousal maintenance. It's important to remember that spousal maintenance is tax deductible by the person who pays spousal maintenance, and it's taxable to the person who receives it. That's different than child support, which is not taxable or tax deductible by either party. So those are the 5 issues that we talk about and think about in a divorce case, and those are the issues, if you have minor children, that you're going to have to figure out as part of your divorce settlement. Next, I want to talk about the legal process. When you are getting divorced, the goal is to reach a full settlement agreement. How you get to that settlement agreement varies depending on your situation. I want to talk about a few ways today to reach a full settlement agreement. Legally speaking, the legal term for a settlement agreement is called findings of fact, conclusions of law, and order for judgment and decree. We typically shorten that and call it a judgment and decree. That's a final divorce settlement agreement, and if you're about to enter the divorce process, the goal in your case is to get to that agreement. If you don't reach an agreement with your spouse, you'll need to go to trial. And at that point, it's not a settlement agreement anymore, it's a trial order, but the end result is the same. There will be a document that dictates how your assets are divided, if you have children, what the parenting schedule will be, and if there's a difference between your incomes, whether there will be spousal maintenance or not. The goal, of course, is to avoid having a trial for a whole host of reasons. And most people, fortunately, don't go to trial. The statistics are approximately 90 to 95% of cases in Hennepin County don't require a trial and settle at some point prior to trial. How does that happen? Well, I'll give you 3 common ways that people are able to get a full settlement agreement. The first and easiest way is if you and your spouse can sit down and make some basic agreements on how to divide assets. If you have a general understanding and agreement, you can write it down on a piece of paper, a piece of notebook paper, and bring it to a lawyer, and the lawyer can draft that document into a settlement agreement for both of your signatures. It's important to understand, though, that if one person meets with a lawyer, that lawyer can only represent the person with whom they meet. A lawyer cannot represent 2 spouses in a divorce case. That would be considered a conflict of interest. So, if you have a general agreement, one or the other spouse can meet with a lawyer, have the agreement drafted, and then the other spouse can choose to sign it or go meet with their own lawyer to make sure that their interests are protected. Once there's a meeting of the minds and understanding, the 2 parties can sign the document, and that can be the end of their case. They don't necessarily need to go to court or need to go to a mediation. That's a simple and cost-effective way to get divorced, but of course it doesn't work for everybody. Often people have disputes. If they have disputes, if they sit down and let's say they agree on a number of things, but they say, we can't agree on spousal maintenance, a good next step is to hire a lawyer and then discuss going to mediation. Mediation is a process in which the 2 spouses sit down with a third party called a mediator. The mediator's role is to be neutral and to help the parties discuss and figure out a settlement in their case, and to help the parties see the case from the other party's point of view. Sometimes parties will attend the mediation with their own lawyer, and that is a way in which you can get advice at the mediation from a person who's there to advocate for your interest and make sure that your interests are protected. Frequently, cases settle at mediation. And if you reach an agreement at mediation, your mediator will often write out a short agreement on paper that's a mediation agreement. That doesn't quite get you divorced. It simply gives a framework of agreement for you to give to a lawyer to draft into a stipulated judgment and decree, as I referenced earlier. So, as I mentioned, the first way and easiest way probably to get divorced is to simply reach agreement with your spouse and have a lawyer draft it. The second way is to attend a mediation, and hopefully your mediation is successful, and then take that mediation agreement and bring it to a lawyer. If neither of those 2 ways work, the third option is to go to court, to file your case with court, and then use the court process to help you reach an agreement. There is, I think, often a misunderstanding about what going to court means, and whether if you file your case, that means that you are now going to have a trial. It doesn't mean that. Going to court in the modern day means that you will meet with the judge, and the judge will refer you to a specific kind of mediation, which is called evaluative. And in that case, the mediator tries to give you more input and feedback and probably a little bit of pressure to try to settle your case. Again, that's a confidential process, and if that mediation process doesn't work, you go back to court and they try something else. They usually will give it 3 or 4 tries through the court processes before you end up in a trial. And a trial is simply an opportunity for you to present your side of events and your spouse to present their side of events to a judge, and so the judge can make a decision about your case. So that would be the third way to settle your case, and hopefully the one that you don't have to undertake, which is going to court and going through the trial processes. As mentioned, through that process, there's still a good likelihood that your case will settle along the way, and if it doesn't, you'll have a judge making your decision for you. I do want to correct something that I often hear from clients when we talk about that process, which is people will sometimes tell me, we don't need to hire any lawyers because we're going to go to mediation. And I usually gently correct that idea because mediation and using a lawyer are not mutually exclusive. A mediator is somebody to help you reach an agreement. A lawyer is somebody to help make sure that agreement is in your interest and also help make sure that it's properly drafted. Which brings me neatly to my third discussion point here today, and that's choosing a lawyer. People, as I mentioned, will ask me, do I need to hire a lawyer? And when I hear this question, I always hesitate to answer because though my answer is yes, I realize that it can sound self-serving to say that. But let me put it to you like this. You're in a process that will involve discussion and or transfer of your assets, your house, your income, and if you have minor children, parenting time with them, as well as monthly money transfers to your spouse or received from your spouse. Essentially, for most people, it's all the things that are important to them in their world: their job, their house, their children, their assets. Hiring a lawyer means you're hiring somebody to protect your assets and make sure that the process protects your interests and makes sure that it's done properly. If you come to your lawyer with agreements already in hand, that will serve you well. That will save you money and that will save you time. You're also welcome, and it certainly is a good idea for a lot of people, to go to a mediator before you see a lawyer, or at least meet with a lawyer and then go see a mediator without the lawyer present to help you reach some tentative agreements. The more agreements that you can have coming into your lawyer's office, the quicker and more efficient the process will go for you. But my advice to all people who ask me is, if you're going through the divorce process and you have agreements, have a lawyer draft that agreement to protect your interests. And it's basically like buying an insurance policy to make sure that it's done correctly, thoroughly, and that nothing is missed, so that you'll have a thorough settlement agreement that you won't need to revisit down the road and come back to court or back to a lawyer on what would be called a post-decree matter. How do you pick a lawyer? Divorce is an emotional process, and choosing the right lawyer is an important decision for you. It's somebody to whom you're going to be working closely with, somebody who is going to help you make big decisions in your life, and somebody who you should have a confidence in that they're both knowledgeable and have your best interests at heart. I recommend sitting down with at least 1 or 2 or even 3 lawyers, calling around to see if they offer a free consultation, and making sure that it's a good fit. Many people who meet with me ask me out of the gate, either on the phone when I first talk to them or when I meet them at my office, how much is your hourly rate? And that's a really sensible question, and it's a valid question. And of course, I'm happy to offer that information. But I would tell you that that's probably not the best question if you're wondering what your case is going to cost. Because there are lawyers who have lower hourly rates who spend a lot more time on your case and are going to end up with a higher bill at the end of the case. And there are also lawyers with high hourly rates who work really efficiently and are able to use lower billing people such as paralegals and legal assistants to keep costs down on your case. And so I would suggest that the best question that you can ask when you want to know what your case is going to cost is, how much did this lawyer's last case cost for the client? And what's an average cost for clients at that law firm for their divorce case? Lawyers should have that information, and that will give you an average cost of what you can expect to spend in your case. Now, of course, costs vary greatly, even within the same law firm. People who have a lot of agreements up front and are able to come in with either a full settlement agreement or a mostly full settlement agreement are not going to have a very expensive divorce case. People whose cases go on for over a year and end up in a trial setting are going to have a very expensive divorce case. But within that range, lawyers are frequently able to predict with some degree of certainty where your case might fall in that line and how much your case might cost. I want to talk for a moment about how lawyers bill. Most lawyers bill on what we would call a retainer system, and most lawyers will ask for a retainer. A retainer is simply a sum of money. When you pay a retainer, often in maybe the $2,000 to $4,000 range, that money will go into your lawyer's trust account. That money's not earned, and the lawyer cannot spend that money until they earn it. And there's very strict rules governing lawyers' trust accounts. So when you pay a retainer, that money goes in your name to be held in trust by the lawyer. At the end of each month, they'll send you a bill, and they'll tell you how much time they spent on your case, if there's any filing fees or other expenses in your case, and how much money they took from your trust account over to the lawyer's operating account. That is how a retainer system works. And so when you hear a lawyer ask for a retainer or sign a retainer agreement, that's what they're talking about. There are also lawyers, although they are rare, you can find them, who will work on a flat fee. Generally speaking, the flat fee is a guess at how much the case will cost. And if you want cost certainty, you are welcome to look for a lawyer who bills on a flat fee basis. So those are some basic thoughts about hiring a lawyer. I hope that this webinar was helpful to you and that you got some basic information about the divorce process. Please understand that nothing that I said here can be construed as legal advice, but just general ideas about the legal process. If you have questions in particular about your case, you should meet with a qualified legal professional to answer those questions. Thank you very much for your time, and I wish you good luck.